Donald Trump didn't walk in like a man attending court. He sat like someone daring it to touch him. No entourage, no small talk, no gestures of cooperation. Just a stillness sharpened by contempt. Pam Bondi sat beside him, chin lifted, earbuds in but silent, the translation channel off, not because she didn't need it, but because she didn't care. They weren't here to listen. They were here to outlast. In front of them sat 3 thick binders labeled in all caps. Executive Order. No slogans, no signatures on glossy cardstock. These weren't press releases. They were artifacts of authority pages that had once moved with the weight of the presidency. But today, that weight was inverted. These documents weren't protected by power. They were about to be dissected by it. And the blade would not come from the bench. Not yet. It came from Jasmine Crockett. She stood before a room engineered to suppress expression. No cameras, no live feed, no audience applause. But none of that mattered. Her presence was the broadcast. She didn't flip pages or adjust posture. She looked ahead and spoke like someone who had already buried every rebuttal. "This is not about what he said," she declared, her tone clipped and fireproof. "It's about what he signed, and what those signatures tried to erase." On cue, a screen blinked to life behind her. 3 executive orders filled the air like evidence hung in light, lines of text, sterilized on paper, but poisonous in purpose. Orders that forbade certain law firms from representing plaintiffs against the federal government. Not for misconduct, for dissent, for filing lawsuits, for doing their job. One clause flashed longer than the rest. Shall preclude any firm deemed adversarial to the interest of the executive office. No citations, no definitions, just a quiet threat in bureaucratic dress. Crockett didn't raise her voice. She let the silence beg for clarity, then delivered it. "These aren't policies. These are punishments, sealed in ink and signed with malice." There were no gasps, no shifting chairs. Just the kind of stillness that signals everyone in the room understood exactly what they'd just heard. It wasn't a charge. It was a diagnosis. Across the courtroom, Trump didn't flinch, but his stillness had changed. His fingers stopped tapping. His eyes stopped scanning. Even Bondi leaned forward now, the tilt of her head betraying more calculation than confidence. And then, Judge Tanya Chutkan moved. Not to interrupt, not to object. She simply reached forward, capped her pen, and set it down with the deliberation of someone making a mark, not a note. No one spoke. No one needed to. The message was clear. This wasn't a trial about theories. It was the start of a reckoning, and the next move belonged to the law. "Proceed," Chutkan said, and the floor returned to fire. Trump rose with the casual arrogance of a man who still believed the room was his. No oath, no apology, just posture. One hand slid into his coat. The other held nothing. No notes, no documents, no evidence, only the illusion of entitlement. He spoke not with the urgency of a man defending himself, but with the smirk of someone who thought history owed him a refund. "Since when does defending the presidency require your permission?" he said, his voice dry with mockery. The phrase didn't land like an argument. It landed like a line rehearsed too often in front of mirrors, talk show hosts, and donors who cared more about sound bites than substance. He didn't pause for effect. He paused because he expected silence to obey him. Then came the list 60 lawsuits filed against his administration, each one, he claimed, funded by left-wing operations posing as non-profits. The claim wasn't new. What was new was the way he packaged it. "These were not firms," he scoffed, pacing just enough to remind the room of his TV instincts. "They were political proxies in suits." He said it like a punchline, as if the legal profession were a Netflix conspiracy and not the only thing standing between citizens and unchecked executive power. But no one laughed. Because calling law firms proxies for suing the government is like calling fire departments arsonists for showing up too often. Crockett didn't interrupt. She didn't need to. She waited for him to finish posturing like a man still campaigning in a courtroom. Then she stepped forward, not with flair, but with finality, and laid down 3 printed copies of the executive orders, each one flat, heavy, and marked like warrants. Her voice didn't rise. It narrowed. "These orders were not drafted to manage the law," she said, eyes locked. "They were crafted to break it." One clerk at the back whispered to another, barely audible, "She's quoting line for line from the First Amendment casebook." But Crockett wasn't reading. She was remembering, because anyone who's fought the weight of executive retaliation doesn't need notes to recall where the bruises landed. The courtroom held still, but the tension didn't. It sharpened. Trump adjusted his cufflinks, looking down at the paper as if it had betrayed him. Pam Bondi remained still, arms crossed, her face carved in the same stone expression lawyers wear when they're paid to defend the indefensible. Judge Tanya Chutkan leaned forward now, her eyes never leaving Trump. Her voice came without elevation, but with the kind of force that doesn't ask twice. Executive discretion does not grant license to target the profession that exists to question it. There was no room left for misinterpretation. She wasn't issuing an opinion. She was delivering doctrine. But Trump, ever allergic to boundaries, muttered under his breath, "I was protecting the office." It wasn't a defense. It was a deflection, one that had worked in press briefings, at rallies, and on every phone call where fear could be disguised as patriotism. Crockett didn't flinch. She didn't even pivot. She just let the line hang like an exhibit. Then, without raising her voice, she sliced back with surgical precision. "You weren't protecting the office. You were protecting the throne." No further commentary. No need to explain metaphors to a man who'd spent 4 years mistaking governance for ownership. The courtroom didn't applaud, but the shift was visible. Even the clerks sat straighter. Because in that single line, Crockett didn't just refute his arguments, he rewrote the power dynamic. Not as a protest, as a correction. And yet, if Trump's brand of delusion had taught America anything, it's that truth alone doesn't shut him down. It corners him, and that's when he gets dangerous. What came next wasn't just defense, it was escalation, and Crockett knew it, which is why her hand didn't leave the paper, because the ink on those orders wasn't dry. It was loaded. Crockett hadn't moved an inch from the evidence table, but the space around her shifted like gravity had quietly chosen a side. She didn't raise her voice. She raised the stakes. We pulled the red lines. We pulled the metadata. And we pulled the witnesses. It wasn't a warning. It was a declaration of readiness, like a surgeon announcing not just the diagnosis, but the incision plan. The courtroom lights caught the glint of a projection screen flashing behind her, now showing 3 internal emails from inside the Trump White House. No redactions, no qualifiers, just quiet, bureaucratic panic preserved in plain text. One from a senior policy aide. Need to reword Second 4 too overtly punitive. The next email, even more revealing, noted that the word disloyal had originally been used to describe law firms challenging federal authority, before someone higher up, presumably with a nose for public relations malpractice, crossed it out and replaced it with the more sanitized non-compliant. You don't edit loyalty out of a policy memo unless you know damn well it doesn't belong there. Crockett didn't gloat. She placed the documents down like affidavits. "This isn't regulatory intent," she said flatly. The syllables clean, clipped, lethal. It's retaliatory instinct. And for a second, you could almost hear the air filter in the courtroom hum, because there was no rebuttal for that kind of evidence. Not a spin, not a slogan, just proof that the orders in question weren't just legally thin. They were emotionally loaded. The legal term for that is bad faith. The moral term is cowardice with stationery. Perkins Coie's lead counsel stepped forward next, face lined, tone subdued but scorched from too many years of defending principles while being punished for them. "We were told not to speak," he said quietly. "That silence would buy us safety." But the silence kept growing teeth. It wasn't testimony. It was confession wrapped in resistance. He didn't need to name who told them. Everyone in the room knew. Executive power doesn't need to shout when it controls funding streams, access credentials, and the threat of IRS audits. And sure enough, Jenner and Block confirmed it outright. They had been warned that accepting another federal case could trigger randomized tax scrutiny. Funny how random always points in one direction. Then, as if summoned by his own pettiness, Trump leaned into the microphone with a smirk sharp enough to cut through ethics. "Maybe don't sue your government and you'll sleep better." The phrase hung there, a masterclass in projection. This from the man who sued everyone from Deutsche Bank to the state of New York for sport, who filed more cease and desist letters than most presidents signed legislation. Coming from him, "Don't sue your government" was like hearing a mob boss complain about excessive subpoenas. If irony had mass, the courtroom ceiling would have collapsed. But Crockett, once again, didn't flinch. She closed the distance to the bench with 3 quiet steps and stopped just short of the lectern. "Maybe don't weaponize the presidency," she said. Her eyes locked on his. "And you won't wake up in court." That wasn't rebuttal. That was the perimeter of her patience. No theatrics, no hand gestures, just the plain truth landing like a verdict before the verdict. Even Judge Chutkan blinked, not from surprise, but from the precision of it. Because that's what this moment revealed, not just the rot inside the orders, but the rot inside the reasoning. This wasn't policy crafted to secure the nation. It was punishment scripted to settle scores. And now, with the red lines glowing on screen and the silence unraveling into confessions, the court wasn't just staring at misconduct. It was staring at motive. And motive in court is everything, especially when it's been preserved word for word in a White House inbox. So the question was no longer whether Trump had overstepped. It was whether the system built to restrain him still remembered how. It was never about who could shout louder. It was about who was still standing after the shouting ended. Crockett turned away from the bench and faced the gallery like a prosecutor addressing not just a judge, but a jury of history. Her tone didn't rise at cut. "These aren't law firms seeking spotlight," she said, voice steady, eyes scanning row after row of legal war survivors. "They're survivors of legal sabotage." No one in the room blinked. Because in Washington, even courage has receipts. And the ones seated behind her had brought theirs. Wilmer Hale's lead counsel stepped forward. He looked like someone who'd once worn suits to meet senators, but now struggled to wear one without remembering the subpoenas. His shirt was wrinkled, his tie undone less from carelessness than fatigue. His opening line was almost apologetic. "We weren't trying to make history. We were trying not to disappear." Then came the story of clients who vanished without explanation, of access suddenly revoked, of case files locked behind passwords that used to work. "Clients vanished," he said, voice rasped. "So did trust." It wasn't a complaint. It was a post-mortem. Next was Jennerin Block's senior partner, a woman whose presence silenced even the skeptics. She stood still, unmoved, unflinching. And then she said it. "I was told our phones were tapped. Our interns got threats. We kept working. 7 words. 1 declaration of war." The room didn't erupt. It froze. Because this wasn't a political ad. It wasn't hearsay. It was a woman with more years in federal court than some presidents have in elected office, saying the quiet part not just out loud, but under oath. The projection screen flickered to life again, this time with a grainy hallway security cam still. It showed a door, a hallway, and a piece of paper taped where dignity used to be. 4 words, all caps, typewriter font, lawyers or traitors. No logo, no return address. Just the kind of note that appears when freedom of counsel becomes a target list. Crockett moved again, slower this time, voice dropping into the kind of tone that doesn't ask for silence, it demands it. "This isn't about ideology," she said. "It's about endurance. And you made law a test of fear." The phrase echoed, not just because it was powerful, but because it was accurate. The executive branch hadn't written policy, it had drafted paranoia. And then, like a reflex, Trump leaned back, hand curled under chin like a man tired of his own show. "Cry more," he muttered, loud enough for microphones but quiet enough to feign innocence. The line might have worked at a rally, but this wasn't a rally. It was a courtroom with a judge who'd already seen one presidency try to drown dissent in bravado. Judge Chutkan didn't raise an eyebrow. She didn't even look up. Her voice landed with surgical indifference. "Careful, that's contempt, not commentary." And with that, the room recalibrated. No more bravado, no more smirks. The illusion of control was thinning, minute by minute. Because in that moment, it was clear. This wasn't a fight between right and left. It was a fight between those who still showed up, threats, and those who handed out the threats. And the longer the stories poured in from the witness row, the more obvious it became that these weren't just isolated cases. They were a pattern with a pen, and the man who signed it was running out of places to hide behind the paper. What came next wasn't just about proving harm. It was about proving intent. And Crockett, as always, was holding the receipts. The room didn't cool off. It calcified. Because what came next wasn't courage, it was calculus. When Paul Weiss was called, their lead partner stepped forward with the polish of a man who still believed dry cleaning could redeem a reputation. His suit was immaculate. His tone pre-rehearsed. His eyes, however, never stopped moving side to side, like someone scanning for exits rather than convictions. "We didn't fold," he said, almost before being asked. "We recalibrated." It sounded like a corporate memo written by someone who'd rather die than say the word cowardice out loud. Their justification was simple. Continuing the lawsuits, they claimed, would have endangered client databases, opened them to cyber attacks, exposed junior staff to online doxing, and rattled shareholders. It was a parade of risks wrapped in the language of risk management. But the real message wasn't buried. It was obvious. When forced to choose between integrity and liability, they went with quarterly survival. Their brand, apparently, didn't include the overhead for backbone. Then came Skadden. Their representative, a bit less polished but no less choreographed, stepped forward. "Our choice wasn't between fighting or quitting," he said. "It was between fire and wildfire." Ah, yes, the language of damage control masquerading as moral philosophy. The courtroom remained still. Not out of respect, but out of recognition. This was what capitulation looks like when it hires a PR firm. Their defense wasn't about law, it was about insurance. And insurance doesn't cover constitutional trauma. Crockett didn't interrupt. She waited. She let them finish their well-structured retreat statements. Then she spoke 5 words, but they hit harder than any filing in the case. "You weren't threatened by Trump," she said, voice like glass cracking under heat. "You were threatened by the mirror." That wasn't rhetoric. That was a reckoning, because what they feared wasn't subpoenas. It was the reflection of themselves blinking at the moment justice needed them most. The screen behind her lit up again, this time with an internal memo leaked from Skadden. 1 sentence, buried in bullet points. "Retreat advised. Maintain neutrality until administration shift." Neutrality. The warm blanket of the corporate class. The preferred accessory of firms who confuse access with principle. Chutkan leaned back in her chair, almost amused, before asking plainly, "And neutrality means what, exactly, when law is gasping for breath?" It wasn't a question. It was a verdict disguised as curiosity. Paul Weiss's lawyer cleared his throat like a man about to quote Churchill, and ended up with something far less durable. "It means knowing when to preserve the firm to fight another day." It was the kind of line that might sound noble in a TED Talk or a shareholder letter. But in a courtroom, surrounded by attorneys who'd taken the hits, it rang hollow. Crockett turned, her voice low but inescapably final. "Some fights don't come back around." That wasn't a warning. It was a sentence, because law, unlike politics, doesn't have a re-election cycle. When you walk away, you don't just lose the case, you forfeit the moment history asked where you stood. And for these firms, the record had already answered. Judge Chutkan didn't bang a gavel. She didn't need to. The sound of paper being lifted was enough. She held the executive order up like a surgeon exposing a tumor on the X-ray. "Section 3A," she said flatly, "prevents firms from engaging in," quote, "adversarial counsel." She didn't blink. She didn't add commentary. She let the absurdity of the phrase hang there, legal English dressed in autocrat's logic. It wasn't a statute. It was a tantrum with a letterhead. Then she lowered the order slightly, her voice dropping into something quieter, but somehow louder. "There's no clause for punishment in the Constitution," she said. "Only process." In a room full of people who'd spent years parsing language, everyone understood what had just happened. That wasn't legal analysis. That was a burial. But Trump, ever incapable of silence when silence would serve him most, interrupted like a man still clinging to the sound of his own authority. "These firms act like shadow governments," he muttered, arms crossed with all the sincerity of a man who once tried to buy silence with a Sharpie. "I just put a stop to it. It was the kind of claim that plays well at rallies but falls apart under cross-examination. He didn't stop abuse, he rebranded it." Chutkan turned her gaze directly to him, no hesitation. "You didn't stop abuse," she said. "You rewrote accountability." That line didn't echo. It stuck, because everyone in the room knew accountability was never Trump's enemy. It was the thing he tried to counterfeit, right down to the font. Crockett stepped forward again, this time not to argue, but to clarify what everyone else was too polite to say. "Intent is the spine of legal consequence," she said, eyes sharp. "And the ink here screams intent." She motioned toward the screen, where a video began to play an old campaign rally, Trump on stage, spotlight in his eyes, face twisted into the performative defiance of someone who never quite understood the separation between government and grievance. "If they come after me with lawsuits," he shouted, "I'll sign them out of existence." Not a soul in the courtroom moved. No one dared. The clip ended. The screen dimmed. But the sentence didn't. It lingered like smoke after an explosion. Because there it was, the confession. Not buried in metadata, not whispered in some hallway, spoken loud, on record, with pride. That wasn't executive strategy, that was vendetta as doctrine. Judge Chutkan turned back to her notes, then looked up once more. "This court finds sufficient ground to proceed to judgment," she said, voice even but unyielding. "Constitutional review begins with the assumption of good faith." Yours expired with the first exclamation mark. It was the kind of line that doesn't need applause to be remembered. She didn't say he broke the law. She said he disqualified himself from it. Trump didn't respond at first. Then he leaned back in his chair, arms folded, eyes drifting to the ceiling like he was waiting for a choir that wasn't coming. "Go ahead," he muttered. "Make me a martyr." The phrase wasn't brave. It was tired. A final attempt to spin failure into folklore. Crockett didn't raise her voice. She didn't even lift her head. Her words came out soft enough to miss, except they didn't. The mic caught every syllable. "You were never the sacrifice," she said. "You were always the sword." And for the first time that day, Donald Trump said nothing back. Because in that room, in that moment, the blade had turned. Pam Bondi rose like someone auditioning for a closing argument in a courtroom that had already moved on to sentencing. Her folder was thickless with facts than with formatting, and her voice carried the tone of someone deeply convinced that skepticism itself was treason. "If law firms represent the people," she began, "why do they only sue their government?" It wasn't a question. It was bait, lacquered in faux populism and served cold. Her hand slammed a remote. A slide flashed up on the monitor, a neat grid of law firm logos highlighted in red, the kind of visual built not to inform, but to indict. She didn't walk the room. She let the bullet points do the walking for her. "This isn't advocacy," she said. "This is lawfare funded and scripted." No one interrupted. Not yet. Not even Crockett. Because sometimes the best way to defuse a bomb is to let the wires tangle on their own. Bondi leaned forward now, elbows planted like a talk radio host mid-rant. The same firms being celebrated today received over $10 million in donations from partisan nonprofits. Her voice sharpened. "We're not in a courtroom. We're in a narrative war." And that was the tell. That wasn't a defense of executive power. That was a confession about political theater. The irony, of course, was staggering. Bondi, accusing others of narrative warfare while presenting a color-coded PowerPoint in federal court like it was CPAC with a subpoena. Crockett stepped forward, calmly, deliberately, as if she were answering a question already erased from the record. "If this is a narrative war," she said, one eyebrow barely raised, "then you just declared truth as your enemy." The line didn't punch. It sliced. Because in that moment, Crockett wasn't defending law firms. She was defending the concept of law itself from people who mistook PR strategy for jurisprudence. But Bondi didn't retreat. She doubled down like a woman whose entire argument depended on volume and slide transitions. "You call it truth," she snapped. "We call it targeted law, coordinated, calculated, bought." 3 adjectives. Alliterative, hollow. It was a verbal PowerPoint without the clicker. But she wasn't aiming to persuade. She was aiming to polarize, and in some corners of politics, that's mistaken for victory. Judge Chutkan let the room breathe for a second, then pierced it with surgical precision. "Ms. Bondi," she asked, voice low and clipped, "are you suggesting dissent should be licensed by political neutrality?" It was less a question than a scalpel, a reminder that in this courtroom, ideology wasn't a shield. Bondi didn't flinch. I'm saying you're watching the weaponization of the legal bar in real time. The delivery was crisp, the logic unsteady, because nothing screams unbiased defender of justice like standing next to the defendant who signed orders to silence the very bar she now accused of being weaponized. Crockett didn't shout. She didn't even shift her tone. She inched toward the podium and spoke like someone who'd lost patience with rhetorical gymnastics. "Then allow me to be crystal," she said, the words smooth as polished steel. "We didn't fight these orders for clicks. We fought them because a silence this deep becomes rot. No dramatics, no index finger raised to the gallery. Just truth, stated plainly. And in a room where every sentence had to pass a constitutional sniff test, that line didn't just hold. It cleared the air. Because what Bondi called narrative, Crockett called survival, and the difference between the two was written in ink, not in slide decks. And the next voice to speak wouldn't be arguing anymore. It would be delivering judgment. Trump stood so fast his chair groaned in protest, as if even the furniture had grown tired of him. "These people never represented America," he barked, the words ricocheting off the courtroom walls like bad cable reruns. They represented headlines, donors, power. He wasn't making a legal argument. He was rehearsing a grievance monologue, the kind that played well to a crowd of red hats but sounded painfully off-key under fluorescent lights and judicial silence. Then came the finger-pointed, shaking, aimed squarely at Jasmine Crockett. "How many times did you sue me, Congresswoman?" he demanded. "How many times did your firm leak filings to MSNBC before court dates?" It wasn't a question. It was an accusation dressed up as a deflection. Because when you're cornered, the goal isn't clarity, it's noise. But Crockett didn't flinch. She didn't blink. She stepped forward, one stride, deliberate, controlled. Her response wasn't angry, it was precise. "I sued you," she said, voice low but unshakable, "because the Constitution gave me that right. I kept suing because you kept testing that boundary." The room held its breath, not because it was shocked, but because it had heard the truth spoken without a single ounce of apology. Trump, for all his bark, wasn't used to people who answered his bluster with case law. He leaned forward again, tone now forced through clenched teeth. "You used the law like theater." Crockett tilted her head slightly, almost amused, then offered the kind of reply that belongs in a history book, not a hearing transcript. "You wrote orders like propaganda," she said. "One of us at least showed up in the daylight." The silence that followed wasn't empty. It was loaded. It was the kind of silence that separates arguments from verdicts. Then she reached for the printed executive order on last time. She didn't wave it. She read it. "Any firm found to engage in habitual litigation against the United States may be deemed incompatible with national security." She paused, eyes still on the page. Then, without raising her voice or her hand, she said, "That sentence doesn't protect a country. It protects a king." And with that, the room exhaled. Somewhere near the witness bench, a Wilmer Hale attorney whispered, not to anyone in particular, "That's it." Because it was. That wasn't a retort. It was the indictment beneath the indictment, the logic behind the abuse. Judge Chutkan didn't break the moment. She didn't even shift her weight. She looked once at the courtroom clock, not with impatience, but with confirmation. No theatrics, no commentary, just the sound of law preparing to speak. "Court will now render its findings," she said. And in that instant, everything in the room, not just the case, but the entire illusion of unchecked power braced for judgment. Judge Chutkan rose slowly, not as a gesture, but as a verdict taking human form. In her hands, she held the judgment, two-sided, cloth-bound, spine-threaded, stamped with a crimson seal that looked less like protocol and more like punctuation. The courtroom didn't stir. It didn't need to. The silence had already learned to behave. She read without hesitation. The court finds the executive orders issued on the following dates to be in direct violation of the First and Fifth Amendments. No elaboration, no disclaimers, just constitutional law applied like a scalpel. And then the blade landed. They are voided, effective immediately, no reaction, not even a whisper, just the soft, surgical sound of someone's pen being set down somewhere in the gallery, as if even note-taking had reached its logical conclusion. This wasn't a moment for protest. It was a moment for reckoning. Chutkan continued, her tone never rising, because power doesn't yell when it already owns the floor. Further, Donald J. Trump shall pay a civil penalty to this court, not for cost, but for clarity. That line cut deeper than any financial sum ever could, because this wasn't about money, it was about meaning, about making sure the ink he used to muzzle justice didn't dry without a consequence attached to every drop. She looked across the courtroom, not at Trump, but through him. No officer, she said, past or present, is immune from consequence. A sentence that should have been obvious in any functioning republic, yet here it sounded revolutionary. And then came the clause that would rattle every boardroom, campaign war room, and whispered legal strategy session for the next decade. For 10 years, she declared, Mr. Trump is barred from issuing, directing, or recommending any administrative policy that inhibits the legal representation of any class of clients, directly or indirectly. 10 years, not symbolic, not rhetorical, binding, constitutional, permanent. A muzzle, not on his speech, but on his ability to twist the law into a weapon again. Trump didn't react, not visibly. His jaw didn't tighten. His fists didn't clench. He just stared, eyes somewhere between disbelief and damage control, as if trying to download what had just happened into a version he could spin later. Pam Bondi leaned in, whispered something urgent and rehearsed. A press angle, maybe. A post-verdict pivot. But he didn't respond. Because for the first time since walking into that courtroom, Trump had no mic, no audience, and no exit strategy. Just a sentence that didn't blink. And a country that had just decided some ink isn't erasable, not even by a president. The verdict hadn't even cooled on the bench before it detonated across every screen in America. MSNBC's Chiron screamed, Chutkan strikes down. Presidency's shadow orders, while Fox, never one to miss a conspiracy cue, countered with deep state bench. By lunchtime, TikTok was saturated with one phrase, ink doesn't make you king. A clip of Jasmine Crockett saying it, in a tone so lethal it didn't need to be loud, became gospel in motion. Zoomers remixed it with beats. Gen X lawyers stitched it into lectures. Even boomers forwarded it under subject lines like, finally. It wasn't a catchphrase. It was a clarifier. 4 words that turned a legal principle into a cultural exorcism. Trump, meanwhile, canceled everything. All press briefings, all media hits, even the paid appearance at a donor dinner in Palm Beach, the one with the preferred steak and preferred questions. His comms team went dark. His usual legal pundits on conservative networks fumbled for spin but offered nothing with a pulse. A few muttered about judicial overreach, but the sound bites came off like elevator music in a burning building. And for the first time in years, Trump didn't flood the airwaves with outrage. Because no tweet could undo what had just been printed into federal precedent. Quietly, the firms that had once bent at the knee began to scrub his name from their partnership histories. The disclaimers disappeared. The press blurbs citing former collaboration were quietly archived. No blog post, no apology, just digital vanishing. Not because they were sorry, because now there was a record, and the record didn't care who paid the retainer. Jasmine Crockett declined every interview. No morning show tour, no victory lap on late-night comedy. The only footage of her that survived the chaos was one clip posted by a courtroom observer. No editing, no music. Just Crockett, standing tall, nodding once to Judge Chutkan, then turning to leave not like a victor, but like someone who had just taken out the trash no one else would touch. Her stride wasn't triumphant. It was surgical, like the work was done and there was nothing left to fix. Judge Chutkan remained at the bench a few moments longer. The room had emptied, but she hadn't moved. She looked down at the thick stack of legal filings, each stamped, signed, dissected. Her hand hovered over the file before gently pressing it closed, like sealing something final. Then, in a tone so low the microphones barely caught it, she said, "Verdicts don't need applause. They need to be remembered." And just like that, the courtroom emptied. But the echo didn't fade. Because in a political age built on spectacle, what lasted wasn't the shouting, it was the silence that followed. The kind of silence that doesn't forget. The kind that writes itself into precedent. The kind that long after cameras are gone still holds.